Frank Figliuzzi, a longtime former FBI official, said to me on the night of the Mar-a-Lago search, whatever is there is something that the government wants back. What have we learned from that moment when this months-long process was revealed by the government in the form of this search? And the fact that Jack Smith's final endgame, at least what is public-facing, has really focused in on what happens between Trump receiving a subpoena and that subpoena being ignored and defied.
That crucial time period when clearly a defendant is on notice, you can't have those. The U.S. government demands them back. Everything after that goes toward the defendant's mindset, right, and his intentions to hold on. And I would argue we've already learned that even prior to that subpoena, there were negotiations where it was quite clear that he couldn't have those. He was told it repeatedly, even as they were leaving the White House at the end of his administration. Pat Cipollone says, yes, I had discussions with the National Archives. I told them we can't keep this stuff, of course. So, but that crucial period after that very sobering subpoena is slapped on you is when you go, I have a choice here. I'm either going to comply with the law or I'm not. And everything he's done after that involves non-compliance with the law and, in fact, thumbing his nose at the law. And as recently as the CNN town hall meeting, as you said, he actually stated, I took those documents. I had every right to. And by the way, if I did show them to somebody, and I can't remember if I did or not, I had every right to. This is defiance that goes toward criminal intention. It's there. And by the way, if the reports are accurate, that the case is all but done. I say, in my experience, these cases don't get better with time. They don't age gracefully. Evidence gets stale. If you've got cooperators lined up, they get cold feet. They get intimidated. The time to do it, if you've got it locked down, is sooner rather than later.
Katie Benner, in the 10 months since, again, this process became public-facing, and that was with the court-approved search of Mar-a-Lago, a lot of things have been said. There's been a lot of bluster, but what has never been uttered by Trump or anyone close to him is a denial of the conduct that constitutes criminality, and that is the taking of classified documents and the refusal to return them. Let me show you some of what has been said.
Did you leave the White House with anything in particular? Are there any memento documents you took with you? Anything of note?
Nothing of great urgency. If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it, because you're sending it to Mar-a-Lago or to wherever you're sending it.
Why did you take those documents with you when you left the White House?
I had every right to under the Presidential Records Act. You have the Presidential Records Act. I was there and I took what I took and it gets declassified.
These are talking points, but they're not legal defenses in a criminal context. And it seems that the end game that Jack Smith has been engaged in, based on what has become public-facing, again, we only know what we know because of what becomes public, has been the work that happens after attorney-client privilege is pierced, after a judge has conceded or agreed that Jack Smith has made the case that crimes have been committed, and that is why he gets to talk to Trump's criminal defense lawyers. Tell me, Katie Benner, where you understand things to be.
So you're right. So Jack Smith has convinced a judge there could be criminal behavior that would allow his team to speak to Trump's lawyers. This is important because Trump was speaking to his lawyers every day, all the time, and they were going back and forth about what he should do in these moments after, for example, communications with the Justice Department and after the raid on Mar-a-Lago. And so what the prosecutors are going to try to prove, and if indeed they are wrapping up, they have or have not, they feel that they either have it or they don't, that Donald Trump knew what he was supposed to do and for some reason defied good legal advice that he was given by people like his criminal defense lawyers, who we know some of them have said has become public in reporting that they have, given Jack Smith's team note that say they told Donald Trump that he was or was not allowed to have classified information, that he needed to give things back, and the dates by which, he needed to return these documents. So that is going to be the crux. As Frank just said, it's going to speak to state of mind. And now that they have that wrapped up, they're going to be debating the strength of the evidence. They're going to be saying, how will a jury interpret this? Will a jury find this convincing? And what are Donald Trump's best defenses against this if we bring this to a jury in a court of law?
Harry, let's talk about, again, that which is public facing, which we all know from 7 years of talking about and covering the investigations into Donald Trump is never everything. But that which is public facing is some of what DOJ has revealed in the extraordinary process for a special master. That was last fall. It feels like 11 years ago, but it was really only about 6 months ago. This is from one of DOJ's filing, and this is about the attestation signed by one of Trump's lawyers named Christina Bobb. Based on the information that has been provided to me, I am authorized to certify on behalf of the Office of Donald Trump the following. A diligent search was conducted of the boxes that were moved from the White House to Florida. B, the search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. C, any and all responsive documents accompany the certification. And D, no copy, written notation, or reproduction of any kind was retained as to any responsive document. So that's in June. We know that after that, a whole lot of classified material is found at Mar-a-Lago. And so the investigation that Jack Smith has undertaken seemed to turn at that point to a very intense focus on the obstruction of the investigation. Tell me where you understand things to be.
As it should. Look, that statement on her part was false, 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 and false. And the most important for her was the addition she made up the top based on information provided to me. What she means by that, by the way, is probably Evan Corcoran. And now we have his 50 pages of written notes. Trump is upset at how detailed they are, that I think leave no doubt at all about what he was told. And to Frank's point, you don't need a lot of extra persuasion when the subpoena shows up. That's a pristine moment that you know it's time to comply. Where are we? I think we've been for many weeks in a kind of final make sure we're, crossing T's and dotting I's, including the latest subpoena report from the New York Times about foreign dealings. Now, the thing about the Wall Street Journal report that really struck me is they do source it to people familiar with the matter. So it does seem that having, done everything he could, including housekeepers, maintenance people, et cetera, and of course, Corcoran and the like, he's about done with the evidence. And we are in the process Katie outlines. I think it'll be straightforward. He's come so far down the road, you just can't see him bailing now. And if he recommends it to Garland, you can't see Garland's declining. So that's where I think we are, really very close based on the Wall Street Journal reporting.
I mean, and just, Harry, to follow up, if Garland did decline, it would be an extraordinary departure from the way Garland dealt with Durham, who just submitted a report a week ago where he said there was no interference in anything I wanted to do. We do have a special counsel standard that has been established on the record by Garland, don't we?
We do. And first of all, yes, he's very deferential. He's made that clear. And under the regulations, he'd have to report it to Congress. It's just very hard to see why he would do it. He has the cover. I shouldn't say the cover. He has the comfort of a professional judgment and a very thorough investigation. Why he's already, I think, made clear that the law applies to everyone. So what would be the basis for turning it down? I think you're very right in supposing he's going to accept the recommendation.